Hello, welcome to the Foundation for Physical Therapy Research's planned giving overview. This is a very casual, informal webinar meant to educate our donors on some planned giving options. I'm Sarah Cioffi. I'm the development manager for the foundation, and I've been getting tons of questions about planned giving options and ways that our donors can leave their legacy behind when when they're no longer with us. So I wanted to chat today with somebody that we're very lucky to be joined by, which is Nora Chatha, excuse me. She's an attorney with Tucker Arensberg. Welcome, Nora.
Hi, Sarah. How are you?
I'm doing great. Thank you so much. So Nora has a breadth of experience in this area. She'll answer any and all of the questions that we've been collecting from our donors and those that we've been speaking to about this planned giving topic. So thank you so much for being here with us and sharing all of your knowledge, Nora.
It's my pleasure, Sarah. And I want to thank my colleague, Paul Welk, who some of the audience may know, who's very active in the physical therapy space, for getting me involved with the foundation and giving me the opportunity to educate individuals regarding planned giving.
Awesome. Thank you too, Paul, as well. He's been a great friend of the foundation. So we're going to go ahead and dive into a few different things. Here's just a high level overview for you. So first, Nora is going to go over the big picture of estate planning. And then we'll dive into all the fun details surrounding tax legislation. I know it's such a fun topic that we're all very well versed in. And what it could mean for you and break it down for us in a friendly and approachable way. So then we'll spend the bulk of our conversation chatting about all of the options that you have for planned giving. And Nora, I'm going to go ahead and turn it over to you to kick things off and give us this fun overview, if you don't mind.
Of course, Sarah. So let's talk about sort of, why someone would have an estate plan, out the gate. And I think that is important because believe it or not, I deal with a lot of individuals, some of whom are middle-aged or older who come into my office without any estate plan in place. And it's quite, sometimes it's quite shocking because oftentimes these individuals will have sizable estates. They will have closely held businesses. They will have complex family dynamics, maybe blended families. They may have charitable inclinations. And they haven't documented any of that in writing so that it would be legally enforceable either during their lifetimes or upon their death. So estate planning is really, really important. A lot of people have this misconception that, well, if I don't have a estate plan, the law will just leave everything to my spouse. Or if I become incapacitated, my spouse will be able to make the decisions for me. And it varies slightly state to state, but the answer is, across the board, no, that's not the case. In most states, if someone dies without a will, the assets pass partially to the spouse and partially to the kids. And if those kids are minors or have unique issues, that's a really, really bad result. Or maybe the spouse needs those assets. And there's also additional tax consequences potentially when assets pass to an individual other than a spouse. In addition, if someone becomes incapacitated as a result of a medical issue or an accident, and they're in the hospital, most states' laws do not automatically authorize a spouse to make medical decisions or to make legal and financial decisions. So it's really important for people to have this documented. And we'll talk about that in particular with respect to charitable giving as well. With estate planning, it's not a one and done thing. And it can be, someone can go into an attorney's office and do an estate plan, and that plan may be good and viable for the rest of their lives. But the reality is, for most of us, there are constant changes that would require us to at least reconsider or think about our estate plan, even if we don't necessarily need to make any changes. Obviously, everyone is going to pass away. That is a constant. So we need to have that in place. In addition, if you look at the statistics, the longer people live, the more likely they are to become incapacitated, which means we need to have a plan in place that addresses not only what happens after we pass, but also if I become incapacitated in my 60s or 80s and I can't make decisions or I can't continue to make gifts to family or charities, we want to have something in place in writing that would appoint someone to take those actions on our behalf, a power of attorney. So that's really important. In addition, what else changes are tax laws, which we're going to talk about in just a few minutes. And of course, individuals have personal change, right? The family dynamic will change. It may be that children are younger and we don't think they would be good agents to make decisions, or maybe they're minors and they can't accept assets, but then they age, they mature. And sometimes during that age or maturation process, we may learn that someone has a disability or they're unable to manage funds, or perhaps they unfortunately have some sort of addiction or substance abuse issue, and we don't want to leave assets to them. Maybe there's marriages, children get married, we may not like our in-laws. So those types of things we need to keep a close eye on. In addition, assets change, right? As we are in our earning years, we grow, we save money. It may be that we're saving it in retirement accounts. Maybe we have a closely held business that we then liquidate, and we go from having an illiquid asset to something that's quite liquid. And then as people age and retire, they're of course then spending down and eating into some of those assets, and they have to take required minimum distributions from their retirement accounts. So there's always a change, and during that time, of course, laws will change, taxes will change, and goals will change. So for that reason, it's important to have an estate plan in place, and every few years, or at minimum, whenever there's a change in circumstance, to revisit that plan. And that's a question when clients come in to sign their documents and they leave, they often say, well, when do we need to see you again? And I tell them, well, if there's a major change in the tax laws that would affect you, we will have a client blast or alert. So we'll let you know that you probably need to come see us. Other than that, call me obviously if there's a question, but call me when something changes. Your son is getting married. Your son has had a child that has Down syndrome. You're about to sell your business, and you have charitable wishes. At that point, we'll talk. Maybe we don't need to do the whole plan from scratch, but we can see if it still makes sense. And when we do comprehensive estate planning, which is on the next slide, it's not just where do the assets pass when I go. So, an important part of it is obviously identifying, understanding, valuing the assets, but we also need to think about, are those assets, are they appreciated? Do they have capital gains built in? We have to think about the beneficiaries. Who's going to receive those assets? Is it a family member that maybe shouldn't receive them outright because they do have a spending problem, or we don't like the in-law, or they have a special need? If the beneficiaries, for instance, are both individuals and charities, there can be some, depending on the state, there can be some very specific planning techniques that we want to put in place. And to give you just one example, if an individual does have appreciated assets and they have cash, it's better to give the appreciated assets to the charitable organization and the cash to an individual. Because oftentimes when the person who's received that gift sells the gift, if it was a gift that has a built-in appreciation or capital gain, when they sell it, they're going to have to pay that tax, which lowers the value of the gift. So you really need to think very carefully. Obviously, we want to plan for income and transfer taxes, for retirement, long-term care needs, and again, consider charitable giving. And in all of this, we have to think about the fiduciaries. Who's going to be my agent if I become incapacitated? Who will be the executor or the administrator of my estate? Who's going to manage my business if I can't? Who's going to hold assets in trust for my minor or younger children? So those are all really important things that need to be considered. So the next slide talks about, revisiting your plan and creating your will. I do see clients from time to time say, well, can I just go on LegalZoom and do a document? And the answer is you can, but I can give you an example where that's really backfired with the client. We had a woman whose husband had passed away. She needed to administer the estate, and she came in to see us, and she brought the will that they had done on LegalZoom. And what they had done is the will was very specific. It said, I give my house to my wife. I give my XYZ bank account to my wife. I give my vehicle to my wife. And it ended there, and it appointed wife as executor. That was great. Those three assets are going to go to the wife. The problem is the will didn't have a residual clause or a residuary clause. It didn't say where everything else that wasn't named was going to go. And of course, between the time that gentleman did that will and died, his asset profile had changed dramatically. and he had retirement accounts, and he had different bank accounts. Because there was no residuary clause giving that to the wife, the intestacy laws kicked in, and the kids got half of everything else, which wasn't a good result. So that's the reason why talking to a competent professional really can make sense. And if you do have charitable, inclinations, and you're working with an organization such as the Foundation for Physical Therapy Research, they may not be attorneys, but they've been in this space for quite some time, and they can be a very good guide to help clients understand not only why they need essential estate planning, but sort of to point them in the right direction for how they can accomplish their charitable goals. And Sarah, is there anything you want to add with regard to how your foundation staff, walk through a plan with either financial advisors or legal advisors?
We do offer several tools on our site, which I'll mention at the end of this recording, Nora, and we do point our donors to some more legal advisees or advisors in order to do this. But we certainly can guide our donors in different ways that they're able to participate in planned giving of any kind. And we do have some forms within the foundation that have been, reviewed and approved by attorneys as well, that we can use to help guide where the funds that somebody leaves behind will be dedicated to.
Great, great. Well, let's go into sort of the tax update so we can just understand why, estate planning is important and why charitable giving can really help to avoid both a federal estate and gift tax, and then also avoid maybe some income tax. So in 2024, when we talk about, let's go with death tax first, there is a federal tax on gifts and on estates. That's the federal gift and estate tax. Every state may have its own inheritance or estate tax. Many states have none. Some states have an inheritance. Some states sort of mirror what the federal government does. But regardless of where you live, if you're in the US, you're going to have the federal estate and gift tax. And at the federal level, everybody has an individual exemption or an amount that he or she can give away during lifetime or leave at death. And I say or because those gifts and those transfers at death, they are joined. So whenever someone dies, the federal government, the IRS looks and says, okay, what did this person gift during their lifetime? And what is being transferred as a result of their death? And if that combined amount exceeds that person's individual exemption, then there is federal estate tax. It is a 40% rate, which is pretty high. Now, the exemption is pretty high currently, but it is going to decrease in 2026, as we'll talk about. For this calendar year, the individual exemption that everyone has is 13.61 million. That's a high exemption. And there is a concept of portability, which means if one spouse doesn't use his or her exemption, they can leave it to the other spouse. This has to be done with a timely filed federal estate tax return, but that can really make the planning easier in some ways. So if we think about this portability, that means between a couple, they can really leave or give during their lifetimes in excess of $27 million without paying tax. But what is going to happen is these really high numbers, and these are high numbers, right? To have to deal with the estate tax is a good problem to have. That means you're wealthy and you've been successful. But those numbers are going to decrease. That individual exemption is going to decrease in 2026. And at that point, it's going to go from what might be close to 13 or 14 million down to about 6.5 million. Still can be split between spouses, but that means, many more people will be impacted by the estate and gift tax. So if a couple has a combined estate of, let's say, over, 13 million or so, they need to be thinking about doing federal estate tax planning. And one of the planning techniques that we actually see clients use is that they may gift to charity upon their death. And I'll give you a great example. I had clients in yesterday. They've been very successful. They've done a lot of planning. I won't get into it. But at the end of the day, when the last spouse passes, they're going to leave whatever their exemption amount is to their kids. So if they died this year, they would end up leaving, roughly $27 million to their kids. They have a large estate, but they have about another $30 million. If that 30 million were to go to their kids, it would be taxed at the rate of 40%. But instead, these clients, because they've done so well, they're charitably inclined, whatever that exemption amount is will go to the kids, and everything else they are leaving to a charity. And transfers to charity at death, there's an unlimited charitable deduction. So when someone dies, they can give as much as they want to charity, and they're not going to have to pay any tax. So it's a great way to fund the charitable wishes and to avoid the estate tax. And it makes the planning simple for me on my end. In addition, and that unlimited charitable deduction, that applies both to gifts at death, estate tax, and also gifts during lifetime. You can give away as much as you want. Now, there are limits as to how much of an income tax benefit you can get, but you can give away as much as you want. So we know that we're going to have, unless the law changes, these individual amounts decrease pretty significantly in 2026. So people really need to be thinking about this. And one of the things that legislations have wanted to do over the years, including the Biden administration, which this next slide talks about, is some changes. And some of the planning techniques that are more complex involve charitable trusts and annuity trusts and unit trusts. Or maybe the use of donor advised funds. And those types of techniques have been in both parties prior administrations sort of agendas to change those. And one of the things that we'll talk about is maybe some legislation that would change donor advised funds a bit, because donor advised funds, as we're going to see, they're not quite as regulated, and so there's less transparency. And for that reason, there's some legislation that will maybe change that, I should say, in the near future. So I want to talk just really briefly about what's called the Secure Act and what that does for retirement accounts, because this is really relevant for estate, tax, and charitable planning. So it used to be that when you had a qualified account, an IRA, a 401k, whatever it was, you could leave that to a person. If you leave it to a spouse, they can roll it over and it becomes their own. They then own it. But if you leave it to a child, a grandchild, a sibling, a friend, a significant other, they were able to stretch the distributions that were required over their lifetime. And how these accounts work is when you do have a qualified retirement account, there are required minimum distributions. You have to begin taking money out of that account at some point so you can have taxable income. And for an individual, the age at which required minimum distributions, it changed under the Secure Act 2.0. And it went from, 70 and a half to 72. And then it went from 72 to 73. And in 2032, it's going to go up to 75. So when individuals who own these accounts hit those ages, they need to begin taking required minimum distributions. In addition, when an account owner dies and they name a beneficiary on that account, whoever the beneficiary is required to take money out at a certain point. And one of the big things that the Secure Act changed is that instead of any beneficiary of a retirement account being able to stretch the distributions that are required over that beneficiary's lifetime, they're now generally have to take those distributions within a 10-year period. So what that means is that the income tax benefit that you could have gotten historically from, naming a beneficiary on a retirement account, because the beneficiary, if they were younger, if it were a grandkid, could have pulled that out over a 40 or 50-year period. That benefit is now eliminated for many beneficiaries because there is this 10-year rule. And so basically for every beneficiary, they are going to have to withdraw it within 10 years unless the beneficiary is a spouse or a minor child who is 18 or under. And that's only a minor child, not a minor grandchild or niece or nephew, just a minor child. Or if a beneficiary is disabled or chronically ill, they can stretch. But everybody else, adult children, grandchildren, they're going to have to withdraw from that retirement account within 10 years. And every time you withdraw from the retirement account, it's all comes out as taxable income. And so that's a really big change. And we see now a switch, where many clients may have used that retirement account as a good income tax planning tool and named the grandkid as the beneficiary, so it could be stretched over the grandchild's lifetime. Now they say, no, if we do that, this grandkid's going to have to pull the money out within 10 years. Every year there will be a tax hit, maybe significant. So we are now seeing clients name more and more charitable organizations as beneficiaries of the IRA. Because of course, the charity has to take it out too, but the charity is not paying income tax. So, that's where identifying your assets and saying, what are my goals, and deciding which asset is better to go to the grandkid versus the charity. Your advisors can really give you some good tips there. The other thing that the Secure Act did is it changed, the age at which you have to take required minimum distributions. And it also got rid of some of the harsh penalties for failure to take those. It used to be that if you failed to take a required minimum distribution, there was an excise tax of a potentially 25 or 50% on the amount that you failed to take out. So not only are they going to tax you on the income that when you take it out, but then you have even more because you failed to take it out timely. The Secure Act is going to reduce that down to about 10% if you correct it in a quick way. The other thing the Secure Act did is it allowed for some additional charitable contributions. Now, we're going to talk about a qualified charitable distribution, and that's something that's always been allowed. But the Secure Act allowed for additional charitable giving from qualified accounts on an annual and then a lifetime basis. So we will talk about that as we get into our plan giving options, if we want to go to that slide, Sarah.
All right, great. Excellent. You have done such a wonderful job of breaking down this very valuable information and making it much more digestible than it is to just read the legislation, quite honestly, Nora. So we really appreciate that. And everybody I talk to, unless they have been involved in the legal side of finance in their careers, they're kind of like, where do I start? Or they are very, heavily reliant upon their attorneys or their estate, planning advisors to inform them of all of this. But it's certainly something that could take people by surprise, it seems, especially with those really significant legal changes coming forward.
Yep.
Yeah. So these are lots of important aspects for all of us to consider here. And it's really important for everybody, obviously, to stay informed about the changes and then the tax implications every year and the changes going on there. So if you do have any questions after listening to Nora, and when we get into some of these plan giving options, to talk about the tax legislation a little bit more, please don't hesitate to reach out, and either of us would be happy to help you with that. And we will provide Nora's information at the end of this recording, as I said. So we'll go ahead and get into the actual different options that people have when it comes to planned giving. So this is the part that I love to talk about, right? And this is the part that I'm fortunate to get to talk to a lot of our donors about. So there are many things that our donors can do in terms of annual giving or setting up some, accounts or endowment funds with us now. However, we've talked about this combination of giving where people can then talk about leaving their legacy behind. And so we'll go over some charitable bequest options. A lot of our donors are now, this has become much more popular in recent years. A lot of our donors are looking into the option of the charitable IRA rollover and the minimum distributions. And, so we are getting a lot of annual donations in that way now as well. And then the donor advised funds, people refer to them as DAFs lovingly. And then of course the gift designation. So I'll go ahead and say, let's dive in. And Nora, I'll just ask that maybe you give a brief overview of each one of these, and then we'll go into some questions in particular that donors have asked the foundation about.
Sure. So let's start out with a charitable bequest. And maybe you've heard the word bequest, maybe you've not, and say that's a weird word. Well, a bequest is essentially a gift or an entitlement to an asset under a will, right? If you transfer assets during lifetime, it's a gift. If assets are left to someone under a will, it's called a bequest. And so a bequest can either be in someone's will or in their trust. A trust is oftentimes a will substitute. It's a vehicle that has all of the dispositive provisions. And in some states, a lot of practitioners use a pour over will, and a revocable trust. So the will may simply say, I leave everything to my revocable trust. The trust is the document that says I give half to my wife, 20% to each of my kids, and then a charitable gift. So a bequest is a transfer, or really a gift, under either a trust, under a will. And there's different ways that you can make a gift, and we sort of have this legal terminology that we use to describe them. One would be a specific gift, right? So if we're talking about the charitable planning context, I have some clients that are very specific. I'd like to leave $10,000 to each of these three charities and my religious organization. Other clients may say, well, I want to make sure they get at least that much. So we have a specific bequest of $10,000 to each of those entities. But then they say, look, if I have, a sizable estate, I want to then give, $100,000 to each of my kids, and the balance, the residue, I want to give to those four charities in equal shares. So that would be a residual bequest. So there are different ways that this can be structured in a will. And oftentimes it's sort of a moving target, right? Some clients may say, well, I want to give, at least, and maybe it's tied to a religious, thing. For instance, I want to give, at least 10% to a religious organization or to a charity. And maybe when we do the plan, 10% of their estate is $100,000 because it's $1 million estate. But what if they when they die, they've been very successful and they now have a $10 million estate? Well, in that instance, a client might say, I give 10% of my estate to the charity, but at least a minimum 100,000. So there's different ways that can be crafted to capture a client's intent. And Sarah, what types of questions do you typically get from clients regarding charitable bequests and planning?
Yeah, great. Thank you. So you've touched on some of them, but are there any other types of assets that you have seen that people are leaving in these bequests to the charitable organizations?
Yeah, so to give you an example, oftentimes, it may be that they say, I want to leave, 10% or $100,000 or $10,000 to this or that charity. And the clients oftentimes think, well, is cash the best thing to leave? That's simple. I give $10,000 from my estate. And that's fine. It captures the charitable intent. But when we talk about a gift, a transfer at death, particularly, we need to be thinking about transfer taxes. Now, assets that are in a person's estate generally receive a step up in basis to the date of death value. Meaning, and I'll give you a prime example. If I have some stock, let's just say it's Exxon stock, and I bought it at $10 a share, and it's now $100 a share. When I die, the basis is going to go from 10 to 100. So if I leave that stock, for instance, to my children, they are going to get that at $100 basis. And when they sell it, they have no gain. Now, I'm going to distinguish that from if I want to gift that stock during my lifetime. If I gift that stock to my children during my lifetime, even though the value might be $100 because it's appreciated so significantly, my children take my cost basis, meaning their basis is $10 a share. So when they sell it, they now have a $90 per share amount that is going to be subject to capital gains tax. So when we look at this, we need to distinguish, are we giving away during lifetime or giving away during death? And in that example, if I want to make a charitable gift and I'm doing it during my lifetime, a really great thing I could do would be to give away that stock that's appreciated to a charity during my lifetime, because the charity, when they sell it, they pay no capital gain because they're not an income tax paying entity. Whereas at death, if I want to leave something, my children get the step up in basis, so I don't have to worry about that. So, we see clients look at it that way. And as I mentioned earlier, when we talk about these retirement accounts, they don't get a step up in basis to date of death because they have not yet been taxed from an income standpoint. So if we have clients that say, look, I want to leave $100,000 to a charity, it might be better to, instead of putting $100,000 of cash under my will goes to the charity, maybe that client will name the charity as a beneficiary of the IRA up to $100,000. Because remember, when the charity is the beneficiary and the charity is forced to take money out of the IRA, the charity doesn't pay that income tax. Whereas if the child inherits the IRA, when the child withdraws $100,000, the child pays income tax on that. So that's something important. And any asset, can be left to a charity. They may use life insurance. It may be a retirement account. It may be a business interest, a personal property, real estate. So it can be done in very different ways.
Awesome. And we're seeing our donors get really creative with this. They're obviously being advised by some pretty smart cookies, because we're seeing a lot of these different forms of charitable giving coming our way to the foundation. And it's like you said, the tax implications, it's just a smarter way of doing it, and then leaving to the organization that they want to. So bequests are clearly a great option for charitable giving, but let's talk about a scenario, Nora, in which we've had the question, I've already worked on my will. I don't really have any major changes to it. If I wanted to work the foundation in, do I have to start from ground zero, or are we talking about some sort of like an amendment to it to create a bequest?
Yeah, and oftentimes changes to a will or a trust don't require the whole thing to be reworked. As I mentioned, earlier, when clients say, when do I have to come see you again? I say when something changes. And if that change is, hey, I'd like to leave $100,000 to the Foundation for Physical Therapy Research, you're not going to have to pay me to rewrite your entire will. Instead, it's a very quick codicil, which is essentially an amendment to a will, or an amendment to the trust if the trust has the dispositive provisions. So literally, it could be a one-page document that says, I amend Article X of my trust or X of my will to make a specific bequest of cash, or I want to leave my Exxon stock to the foundation. So it can be done very, very simply. And one of the things I wanted to talk about are sort of donation agreements or intent forms, because I have oftentimes clients, maybe that change that they talk about, they come in to see me and they say, hey, I met with someone from the foundation. I do want to give them $100,000. I signed an intention form with them. So that takes care of it, right? That means that will go to them upon my death. And the intention form, and Sarah may have some thoughts on this as well. It's not necessarily carrying the day, because that intention form says, yes, let's say the client's name is Jane Doe. Jane Doe, I intend to give $100,000 to the foundation when I die. But if Jane Doe doesn't go in and do that amendment to her will or change her beneficiary designation on her IRA to put the foundation on there, that intention form she hasn't really carried out the intent. And I've seen cases where that sort of has gone sideways. And one example I'll give you is I had a client who had signed an intention form like that. She wanted to give money to a particular college. But she never modified her will. She never changed the beneficiary designation. When she died, she had two sons, and unfortunately, they were pretty greedy, and they didn't honor that intention agreement. When we were doing her estate, they said, "Look, we don't want to leave money to this school. We don't think that intention agreement is enforceable." Now, of course, in that case, the school, didn't want to fight about it. They said, "Look, maybe Jane Doe changed her mind, so she didn't update her will," and it went away. But the reality is that woman's intention wasn't carried out because she didn't change her documents. Now, in some instances, the beneficiaries of the estate or the executor may say, well, no, mom signed this. She wanted this to be done. We're going to treat it as an obligation that the estate has. And so it can be carried out if the parties agree to it. But if you have people who are greedy or who disagree or question what your intent is, you really do need to take steps to firm up that intent by a will modification or a beneficiary designation.
I'm really glad that you mentioned that, because, as you said, we do have an intention form for bequests and legacy giving to the foundation. But I think it's really important that people hear that there's a second step necessary, and, really confirming that your wishes will be carried out, and that it won't be challenged on either side, because that's a sad story. I'm sorry to hear that happened. So specifically, can donors restrict their bequests for specific purposes? Can they specify how it should be spent?
Absolutely. So I have some clients that may come in and see me and say, hey, I want to give $100,000 to the foundation when I die, but I want them to use it for something very specific, maybe something unique in the physical therapy world, or maybe they say, look, I want to give them this money, but I don't want them to have it all at once, because I want to make sure that they benefit, every year for 10 years after my death. So that client could make a gift of $100,000 to the foundation and say it's to be used for a particular purpose. It has a restriction on it, which then must be honored. generally. And or the client could say, look, I'm going to leave $100,000 in trust for the foundation, and my trustee is to give $10,000 a year to the foundation, or is to give the income to the foundation. So there's always something going to the foundation long after that person passes, not just in the year, the year or two after they die. So that's absolutely something that a client can do, Sarah.
Awesome. Great. Thank you for mentioning that. And we do see this often. So that's part of the intention form that the foundation has. And that's part of the conversation and the relationship building with somebody who wants to leave a legacy to our foundation, that we have these conversations about how you would like to see those funds used. And maybe there's a specific, type of physical therapy that you'd like the focus to be on, or maybe it's for scholarships or grants in particular. So I think that's a really great thing, that there's an understanding there on both sides. That, we will have those conversations, and we'll make sure that, again, your wishes are honored. And you've already answered this last question, Nora, really well, I'd say, but you might want to add something else. Do you have to specify a dollar amount when making their bequest? And I will say that we often see percentages of an estate, and I'm glad that you'd mentioned as well that perhaps a percentage will mean something different when they, when they've passed, when it's enforced, but maybe they say at least a minimum of, like you said, $100,000 in your example. So really they can get creative with the language, it sounds like, huh?
Yeah. So if a client said, look, I want to leave, 10% of my estate right now, that's $100,000. But that client says, look, but I'm a successful business person and I may have a $2 million estate when I die. Well, in that instance, the bequest or the gift may read under the will, I give the greater of $100,000 or 10% of my estate. And that way, if it's the greater and the estate is 2 million, the foundation is getting a $200,000 gift as opposed to a $100,000 gift. So there's very creative ways that we can address that.
Excellent. Great. Thank you so much. You've done a beautiful job breaking down bequests for us. So let's go on and to move on to the next option that we wanted to cover, which is the IRA rollover. And I mentioned before that this is something that we're seeing as becoming a pretty common way of giving from our donors to the foundation. So if you wouldn't mind, Nora, just giving again your overview, and then I'll dive into some of the more specific donor asked questions.
Sure. So this technique is referred to as a charitable IRA rollover, or a qualified charitable distribution, or QCD. And this is a technique that's been in place for a while. And essentially what it does is it says that an account owner of a qualified account, and in this case, it has to be a traditional IRA, is able to make a charitable gift from the IRA directly to the charity, and that can satisfy that individual's required minimum distribution. So if someone is over 70 and a half, they can make a qualified charitable distribution from their IRA. It was initially $100,000. This year it's up to $105,000. And when someone reaches age 73, and under the updated laws, they have to begin taking those required minimum distributions from their IRA. So, if you have a client that has, 7 million in an IRA, that annual required minimum distribution might be about $350,000, which is not insignificant. And that amount, that's all income tax. What the qualified charitable distribution does is say, look, up to that $105,000 amount, you can direct that 105 goes directly from your IRA to a qualifying charitable organization. And if that happens, we'll treat it as a charitable gift. And what that does is it means that roughly 100,000 of the required minimum distribution has been satisfied by a charitable gift, and then the client just has to withdraw the balance, the 250. If the client's RMD is 100,000, that can be totally satisfied by the charitable gift. So what that means is that taxable income never hits that individual's income tax return. It never hits their adjusted gross income. So it's a really, really great planning tool.
Yeah, no kidding. So if the example that you mentioned, if somebody has an RMD of 350,000, 105 of that can be given directly to the charitable organization, and then their taxable income that year is reduced then to 200 something, correct? 200 something.
That's correct. Yeah.
That's incredible. It seems like a no-brainer if somebody is so inclined to give. So that's awesome. Excellent. This topic is a little more nuanced, right? It's a little less frequently referred to than bequests. So I'll ask some more specific questions that our donors have passed by. So can your other retirement plans, so can you look at your 401k, your 403b accounts, can those be used in this way as well?
So the answer is technically not. The QCD has to be from a traditional IRA. However, there's a workaround, right? You can roll funds over from a 401k to a traditional IRA. That's not a taxable event. So if I want to take advantage of this, I could roll funds from my 401k to a traditional IRA, and from there, I could make the qualified charitable distribution.
Interesting. Okay, good to know. Excellent. So what's the minimum age for making this IRA rollover gift? I know you said that there's been a change and there will be another change moving forward. I think you said to
Yeah.
2032 even, right? So what were those ages again?
Yes, the minimum age, you have to be over 70 and a half in the year that you make the gift. However, but then at this point, required minimum distributions for persons, for instance, my age, don't start until 73. And in 2032, it'll be 75. So it's really, and that's where you really have the best benefit from the qualified charitable distribution, is when you have to make those RMDs at age 73. At that point, then it's good because you can have the advantage of the charitable distribution. But again, you can do it anytime over age 70 and a half.
Sure. Okay. And you've already addressed the next question. If you can get a tax deduction from making this IRA rollover, the charitable IRA rollover, which yes, sounds incredible.
This is sort of a technical thing too, that I think it does bring up a really important part of a qualified charitable distribution. Technically, when you make a qualified charitable distribution, you're not getting a tax deduction because your gift it's not, remember I said it's not hitting your adjusted gross income. So it's technically not a deduction because it's going directly from your IRA, which is a separate entity, to the charity. But what it's doing is it's decreasing your taxable income. However, in order for that to work that way, and that's the better result. In order for it to work that way, the distribution must go directly from your IRA to the charity. If you intend to do this and you say, okay, I'm going to tell my financial advisor I want to take $100,000 out of my IRA to make a qualified charitable distribution, if it goes from the IRA to you, that's not a qualified charitable distribution. Taking it out directly to the individual now means that $100,000 hits that individual's adjusted gross income. Now that individual can make a gift, right? And if it's cash, it can be, up to 60% of their adjusted gross income. And then they take a deduction. But if you look at the numbers, the better result is to have it go directly from the charity, or I'm sorry, from the IRA to the charity, so that it's never hitting your adjusted gross income. And that's the better tax result. But if for some reason it does happen that it comes out to the individual, they can still make the charitable gift and they will get a deduction. They just don't get as much bang for their buck. So that's a really important part of a QCD. So if you ever have a financial advisor or someone else who says, oh yeah, withdraw it from your IRA and then give it to us. No. We want it to go from the IRA directly to the foundation.
Very good to know. That's a very good piece of information. Thank you. And can their IRA create an endowment?
So certainly you can use a retirement account to fund an endowment. Now, it'll go from the IRA to the endowment, but absolutely that can happen.
Awesome. Excellent. So we're going to go ahead and encourage anyone interested to talk about this with their, administrator to set this up a little more in depth, but thank you so much for that overview of the IRAs as well and the rollover. We'll go ahead and move on to the third option. Then we're going to talk about donor advised funds. Oftentimes our donors refer to these as DAFs. And these have been growing in popularity recently. We've been having a lot more conversations about DAFs. So Nora, if you wouldn't mind giving us just a quick overview of what this is, and then we'll hop into some more donor questions. That'd be great.
Sure. So a donor advised fund essentially satisfies or qualifies as a charitable gift, and enables the individual who's funding one to get an immediate tax deduction. Now, what's interesting though is that it goes into the fund that then in turn will make charitable gifts from the fund. And so a lot of individuals are using donor advised funds right now because of our increased standard deductions. So you may remember with the Tax Cuts and Jobs Act, they did away with a lot of deductions on the income tax return, and there's a higher standard deduction. So it's about 14,000 for single filers. It's about 30,000 for married couples filing jointly. And with those high standard deductions, many people who don't give a lot, they give maybe $10,000 a year to charity, they're not able to get the benefit of that charitable gift because if they're, the standard deduction is about 30, they're only giving 10 in gifts, they don't get a benefit. So instead, what those individuals are doing is saying, look, I want to give $10,000 a year away to this particular charity or to a cause, or at least to make a charitable gift. But I'm not able to do it every year because it's not giving me an income tax benefit. So instead, those individuals will do what we call cluster gifting, right? And rather than give $10,000 a year, they may give $100,000 in year one, so that, and particularly if it's a high tax year, so that year the gift is above the standard deduction and they get to take that charitable deduction for the gift. Now, the problem is they may say, look, I want to, but I don't want the charitable organization to get $100,000 in year one. I want it to be spread out to make sure that they use it properly, or because I know they're going to have a need in future years. That's where the donor advised fund comes in. You can make the gift in that year one of $100,000. You get the charitable deduction, but it doesn't have to go out to the foundation, in year one. Instead, the donor advised fund enables the individual to make recommendations or grants as to how the funds are used. And they can also say, look, if I can't make these decisions, I want my kids or my grandkids to decide how the funds are used. So it's a vehicle that you can make the gift into and then later direct the funds to come out of. And what's interesting about a donor advised fund is, unlike a private family foundation, which has to distribute 5% of the assets every year, right now, there's no requirement that a donor advised fund has to make a distribution in a given year. So, and that can cut both ways. In a way, it's good if you want to gift in the future. In another way, though, it means that it doesn't necessarily require that charitable giving. And that's one of the techniques that I mentioned that the prior administrations may look at. So a donor advised fund is a really, really great tool. And we've talked about what types of assets we might gift. Well, if we had stock that was appreciated that we want to get out of our portfolio, but we know if we liquidate it, we're going to have to pay the capital gains, that stock could go into a donor advised fund. And when the charity then liquidates it, it's not incurring the gain because it's not going to be a taxable, a taxable entity. And again, business interest as well can be put into a donor advised fund. Interestingly, a qualified charitable distribution from an IRA, that can't go into a donor advised fund. That has to go directly to the charitable entity. So that's a really, really great tool. So Sarah, what kind of questions do you see from your donors regarding these DAFs?
Well, we do discuss this quite a bit. And you mentioned when you said it could cut both ways, we have heard some stories that maybe things aren't as clear with DAF. So I would ask, can the donor at any time, so say they know they want to put money into a DAF, into this fund, but they don't necessarily designate the charitable organization that they'd like the funds to be donated to or distributed to, can they then make that change at any time? Can they put in money now and maybe 10 years from now designate where that, which charitable organization should be receiving that funding?
Absolutely. Yeah. At any time, the donor or the person that the donor designates, right? The kids, the grandkids are able to sort of change. It has to be a charitable gift from the donor advised fund, but that agreement will allow them to modify the purpose or the recipient charitable organization at any time. Yep. And that's the beauty, the flexibility of the DAF.
Interesting. Are there ever times in which the money is never able to be dedicated to a particular organization? And what happens in that case?
Well, if the organization that you'd like the donor or the advisors would like to go to is not a qualifying charitable organization, then the fund cannot make the distribution. It does have to be to a qualifying charity.
Okay, excellent. And can you, just touching on the last thing that we covered, what are the key differences that you would say, in again, a digestible way, for us to understand between a DAF and an IRA?
Yeah, so and I think maybe this example will help. If an individual says, "Look, I want to give $100,000 to the foundation," and let's say they want to take advantage of the qualified charitable distribution, but let's say they also say, "Look," or maybe that's the consideration. I want to take advantage of qualified charitable distribution, but I don't want the foundation to get $100,000 this year. I want it to be spread over a few years. In that instance, the individual would say, "Okay, well, if I do the qualified charitable distribution for my IRA, I know it has to go directly to the foundation. I
Right.
get that tax benefit, but it's all going to the foundation in that year." So in that instance, the individual may use the QCD. Now, if the individual says, "Nope, I want it to go to them down the line," then the individual would be better off putting assets into a donor advised fund, because the donor advised fund can then shell out the money over the next, 10 years, or as the case may be. Because remember, but unfortunately, you can't have the QCD go to the donor advised fund. So that's a distinction between, how a client may make that charitable giving.
Sure. Okay. All right. So, and you've talked about the tax benefits of the DAF, but essentially we're not, the individual wouldn't be, they wouldn't be susceptible to the same penalties necessarily if they took from, like the QCD, where they then took it out into their personal account and then donated. It's not the same type of penalty necessarily if it goes directly from the individual to a DAF, and then
Correct.
it's okay. Excellent. Well, that's good. Is there a time limit on how long the money can stay in a DAF?
Currently, no, and that's one of the things that we may see a change in the law on. Unlike a private foundation, which has to distribute 5% on an annual basis, a DAF doesn't have to do that. So the funds could stay and grow income tax free and come out income tax free from a DAF, almost indefinitely. And in a way, that's a can be a good thing, but it also can be a bad thing, because those funds should be put to charitable use. So
Yeah.
that's something that I think, if I had to bet, in the future we're going to maybe see a requirement that DAFs do make periodic distributions, but right now it's not required.
Sure, sure. So if an individual does dedicate, let's say $100,000 to a DAF, and that does grow within time, would the charitable organization that it's meant to be distributed to ultimately receive that 100,000 plus any interest, or is it
Exactly.
just they
Yeah.
would?
So
Okay.
that's the benefit. So, in a
Yeah.
way, the fact that the funds can stay in there indefinitely and grow means that you down the line, you may be making much bigger charitable, the
Sure.
DAF maybe making much bigger charitable gifts. Yeah. So
Sure.
it can go both ways.
Got it. Okay. And then what kind of assets can an individual contribute to a DAF? Is it solely cash or retirement accounts, or what are we looking at?
Yeah, no, it can be cash. It can be qualified funds. It can be appreciated assets. So the example of the Exxon stock, it can be
Mhm.
business interests. And if someone is selling a business and they think that it's going to be a quite a liquidity event and a lot of capital gains, that individual may choose to put some of the business interest into a DAF or another charitable vehicle before the sale. That way they get the benefit of the charitable gift, but then when it's sold, rather than sell the business for $1 million and say, "I'm going to then take $100,000 of my proceeds and give it to the charity," but they have to pay some tax. If you put it in the fund first and then you sell, you avoid the capital gains that the individual would have otherwise paid.
Okay, great. Excellent. Thank you so much. And then we'll
Yeah.
move on to our last but not least topic of beneficiary gifts. So these are also very popular amongst our donors. And Nora, I'll just ask that you give another brief overview, and we'll
Yeah.
tackle the last of our questions from our donors.
Sure. So, we talked about a gift under a will, a transfer directly from the IRA to the foundation. A beneficiary gift, designation gift, is where you have a beneficiary designation form, which, life insurance has, qualified accounts have, Roth IRAs have. And in addition, many bank or brokerage accounts can also have a beneficiary designation form called a transfer on death, a TOD, or a payable on death, POD form. So this is where you would have the charitable, transfer at death be accomplished not by a bequest under the will or trust, but rather by designating the foundation on the beneficiary form.
Great. Yeah. And this is something that we're seeing done more commonly, that we're receiving the life insurance benefits or even some of the retirement accounts and the assets. So all of these options are really great way to make a powerful difference. But what would a person have to do in order to make that beneficiary designation? Is there a central place that they can specify that they want these different assets to go to a charitable organization, or does it vary based upon the different types of assets?
Yeah, if it's life insurance, let's just whatever the life insurance company is, or if it's an IRA with a particular financial institution, they will have their own forms. So you have to make sure that you're using the form that is for that policy or that asset, and that you submit it to the gatekeeper, the life insurance company, or the custodian for the retirement account, the plan sponsor. As long
Sure.
as the form is completed in a manner that each of those will accept, and it gets to that entity, then it will be enforceable.
Okay. Is it beneficial for the individual, to also specify in the bequest or will that this is another thing that they've designated? Is that ever an issue that may come up?
Well, it sometimes we see an interplay. For instance, I may have someone that says, look, I want to make sure I get, at least $1 million in charitable gifts when I die. And I've named, let's say the foundation as a beneficiary on my IRA using the form. But let's say when that individual dies, the IRA is not it's below $1 million. They've spent it down. It's now only 500,000. There, the will may say, it is my intention to give $1 million to the foundation. To the extent I have named the foundation as a beneficiary, those beneficiary designations shall satisfy this gift. And if those beneficiary designations don't fully fund it, then I make a specific gift from my will in order to ensure that the foundation gets $1 million. That's an example of where we may see some interplay.
Yeah, very good. Very good information to consider. And you've touched on this, I suppose, but can you continue to use your account after you've made your gift? It sounds like, yes, you can. You still have access, correct?
Yeah, just a beneficiary designation form only kicks in when the person dies. So if it's, let's say it is a retirement account, or it's a payable on death with an investment management account, when that
Mhm.
person dies, the designation kicks in. But until then, it's still the person's asset. So they do with it as they please. And, they can update that beneficiary designation form as often as they like.
Sure. Okay. And then any other notes on any key differences between a beneficiary designation and a bequest in particular?
Well, so the bequest is under a will or trust, which means there's administration that has to be done by an executor or a trustee before that charitable gift is made. Meaning, if someone dies and it's under the will, the executor's got to go to XYZ Bank, liquidate that account, and eventually cut a check to the foundation. So it can take a little time. In addition, depending on the state, there may be a probate fee, which says the amount that the executor is handling is subject to a 5% fee that's paid to the local register of wills or the local county. The beneficiary designation, however, doesn't require anybody else to administer it. If the life insurance policy says XYZ life insurance company pays to the foundation, or my bank is to pay on death to the foundation, when that person dies and a death certificate is produced, life insurance company or bank automatically distributes the funds. So it can be quicker, there's less administrative hassle, and if it is a situation where there may be a probate fee, we've avoided that probate fee. So that's one of the benefits of the beneficiary designation over a bequest.
Got it. Okay, great. And then I know you've touched on this and you've mentioned a few times business assets, but would you mind just talking a little bit more about opportunities that folks might have to leave some business assets to a charitable organization?
Yeah. So again, and oftentimes, closely held business assets, it's someone's baby. They've worked really hard for it, but maybe there's been considerable appreciation. And so a person, particularly if they're thinking of selling that business, they may decide that they want to make a gift of the business interest before they sell it, either directly to the foundation or to a donor advised fund. That way, when they do sell it, because they've given away some of the business interests, they are reducing the capital gains that they are going to pay, and they are maximizing the gift. And that's because the DAF or the foundation, they don't pay income tax. So using business interests is absolutely a way to satisfy charitable gifts. And it's a good way, particularly if there's an appreciated business asset and there's going to be a liquidity event.
Yeah, great. Any last takeaways you'd like to share about the options that we've touched on in planned giving so far?
Boy, I think we've really covered them, Sarah, but I mean, anything you can think that we missed?
Not really. I think you've done a
Okay.
fantastic job of elaborating on a lot of the common questions, or the starter questions, I'll call them,
Yeah.
that we're getting from the donors. But you've really put a lot into perspective, and you've talked about some really strategic ways in which people can, as you said before, kind of get the most bang for their buck and satisfy both their, their wishes to give to a charitable organization or leave their legacy, but also, in some ways, avoid some of the harsher tax penalties or implications.
Yep. So plan now and don't just say, yeah, I want to leave it to the foundation or I want things to go to my husband. Document that in your will, in your trust, in your beneficiary designation. Monitor your assets, monitor your family search situation, and monitor changes in the tax laws, and then update accordingly. So that's my best advice.
Yeah, that's really eye-opening, because I hear, Nora, and a lot of these planned giving conversations that I have with other charitable, organizations and planned giving administrators, I often hear that the most common age for people to start looking at and investing into the planned giving options now, or we're talking about 50s and 60s. So I think it's a lot. And when I say that to folks, they're kind of surprised by that. But I think it's really important that a recurring theme that you touched on is, don't just, set and forget. Almost, keep monitoring what any changes may have occurred legislation wise, and what tax implications are now applicable. But also, make sure that you are on top of specifically making any changes with your administrators that you want to see come to fruition. So don't set and forget. But that's been, again, a really good reminder coming from you today.
Great.
Yeah, so I would say that, Nora, you have been absolutely fantastic in breaking this really complicated information down for us.
Thanks, Sarah.
And I know that you have certainly offered to be a resource to any of our donors that would like to reach out to you. So we've listed Nora's email address here, and please don't hesitate either, folks watching now, to visit our direct foundation site for our planned giving, the legacyfpt.org. So we do have a lot of information and resources available for you, a very extensive estate planning guide. So not just talking about, planned giving options to charitable organizations, but just general steps that folks should be taking and looking at, planning the next phase of where their assets should go, and how their family should be covered and their friends and loved ones. So you can also learn more about how and what to give that we've talked about today, but a little higher level in that way. And then we do have a planned gifts calculator as well. So a lot of helpful information on our website for you. And again, I want to talk about briefly our Legacy Society. And this is a really special group of supporters that the foundation has built relationships with, that they've wanted to make sure that they're leaving the foundation in their estate plans, and that they are influencing in such a positive way the future of physical therapy, the profession, and the research that's being conducted with it. So our list is continuing to grow. We are so thankful and appreciative of all those already dedicated to legacy giving and part of our Legacy Society. But please don't hesitate to reach out and speak with me or anybody at the foundation if that is something that you'd like to explore. As Nora has laid out for you today in the presentation, there are many ways to get involved in planned giving with the foundation. And I've thanked you a million times, and I don't think that's enough, because your information has been extremely informative, Nora, and again, really digestible. So kudos to you for a wonderful wonderful conversation. And thank you.
You're welcome. Take care, everyone.
You do the same. Bye-bye.
Bye-bye.